So let's wait for the stream to fire up all across the internet. I'm sort of skidding in here because I was about to hit the let's go live button and I dropped my clicker and it exploded all over the ground. So the batteries went splattering across the floor and I was scrambling to shove them back in before the bell rang for. And it looks like we're just about live. So let's get started. All right, so hello, my friends, and welcome back to yet another episode of Watching the Watchers Live. My name is Robert Gruler. I am a criminal defense attorney right here at the R&R Law Group in the always beautiful and sunny Scottsdale, Arizona, where my team and I, over the course of many years, have represented thousands of good people facing criminal charges. And throughout our time in practice, we have seen a lot of problems with our justice system. I'm talking about misconduct involving the police. We have prosecutors behaving poorly. We have judges not particularly interested in a little thing called justice, and it all starts with the politicians, the people at the top, the ones who write the rules and pass the laws that they expect you and me to follow, but sometimes have a little bit of difficulty doing so themselves. That's why we started this show called Watching the Watchers, so that together with your help, we can shine that big, beautiful spotlight of accountability and transparency back down upon our system with the hope of finding justice. And we're grateful that you are here and with us because we've got a lot to get into today. We're going to start by revisiting the Derek Chauvin case because Judge Cahill today came out with a new order that is basically finding that Derek Chauvin is going to be facing aggravating factors when it comes time for sentencing. And so we want to break down what that means. We have a copy of the order as well. It's going to go through things like whether or not he abused his power as a police officer and a litany of other different factors that are going to be used in sentencing. And this is important. This is going to decide whether he gets, 10 to 12 years or something dramatically longer than that. So we have a copy of the order. It's not particularly long. It's about 6 pages. So we're going to read through that and point out a couple of things. Then we're going to change gears. We're going to talk about the Fourth Circuit Court of Appeals. This case is not really in the news, not much. You may have seen some little blurbs about it. It is an interesting case because it involves the N-word and in particular the criminalization of certain language. There was an individual who was charged with a crime for using abusive language towards somebody else that involved the N-word, and the Fourth Circuit Court of Appeals came out today and said, well, that's not a crime. So we want to go through that opinion as well. Interesting story. It sort of has some free speech implications. Obviously, a absolutely horrendous and disgusting word. And so it can be a little bit provocative when you start to hear the Fourth Circuit come out and say, well, those aren't fighting words. Anybody who knows what that, knows that word knows that it is a fighting word. So you sort of have this little bit of a disconnect there. But there's a good reason for it. We're going to break that down. Then we're going to talk about the McMicheals. If you recall, about a year ago, we were talking about the Ahmaud Arbery shooting that has sort of captivated the nation's attention. We have the McMicheals, Travis and Gregory McMichael. Gregory was the former police officer that was out of this particular area and ended up, sort of chasing down and shooting and killing Ahmaud Arbery. And so those two gentlemen now had a court date today and tomorrow, and they are duking out a lot of the legal issues that need to be hashed out at this moment in time. And so I think there were 12 different legal motions that are now being sort of fleshed out in the court of law that were submitted by the McMicheals, by their defense team. And so we're going to break into that as well. A little bit of an Ahmaud Arbery case update. So we've got a lot to get into. If you want to be a part of the show, I want to invite you to do that by going over to watchingthewatchers.locals.com. It's where you can connect with other people, and we've got some pretty cool stuff coming up. I want to remind you that we've got a couple save the dates. May 22nd is going to be our community virtual meetup. So there's a registration form that is now available over at our locals platform. So go check that out. It's in the pinned comment near the top. So if you want to register for the monthly meetup, it's going to be on the fourth Saturday every month moving forward. So if you want to do that, you can go and register. I want you to register if you are a supporter at Locals, just so we can kind of get a head count. We can see, make sure that our bandwidth is sufficient, get an expectation of how many people are coming. If anybody wants to come at all, I mean, maybe it's just me talking to myself there, but it is coming up May 22nd. Then the next one will be in June 26th. We've also got on Saturday, June 12th, I'm going to host for free, if you're a local supporter, the law enforcement interaction training, which is going to be about a 90-minute training that we're just going to go through some of the most common scenarios when it comes to dealing with law enforcement. What happens if they call you? What happens if they show up at your door? What happens if your kid calls you and they're at their dorm room? You know, there's a lot of different scenarios And, we all drive cars. So what happens if you get pulled over? What do you say? You're supposed to remain silent, but how does that work in reality? Well, we're going to learn more about it on June 12th. So I want to invite you to be a part of that. And as always, you can download a copy of the slides here that we're going to go through here at our watchingthewatchers.locals.com platform. And if you have a question, throw one in there right now in the live chat, because Miss Faith is going to clip those and then we'll address them after each segment. So, all right, enough of the introductory stuff. Let's get into the news. Derek Chauvin is back in the news because he is getting scheduled for sentencing, and Judge Cahill just today issued a new order that is saying that some of the aggravating factors that they were fighting over are going to, in fact, apply to Derek Chauvin, which means that the potential sentence that he faces is aggravated. It means it gets worse. And so we want to break down what is going on here. To start, we're going to get some background information coming over from CBS Local, the Minnesota affiliate. You may remember, we spent a lot of time on this channel talking a lot about Derek Chauvin. We covered the entire trial. And the trial's, it's done. It's over, right? Derek Chauvin has been convicted. He's got 3 convictions, all 3 charges. But he hasn't been sentenced yet, and that is something that is up to the judge to decide how much time a person gets. So, when you're doing a trial in front of a jury, all the jury is doing is helping us decide what the facts are, whether or not somebody did something, and then the judge gets to decide what the penalty is. So we're sort of done with the fact-finding phase of this case. Now we're moving into the sentencing phase, which is a whole different can of worms. I mean, there's a lot going on here. And I want to show you a little bit about how this works, but let's start by getting some background information over from CBS Local. This article says that Derek Chauvin's conviction, a judge says that the prosecutors proved multiple aggravated sentencing factors, including cruelty. Judge Peter Cahill said that they did so beyond a reasonable doubt. They proved some aggravating factors, including the cruelty. Minneapolis police officer Chauvin was convicted. He's set to be sentenced on June 25th. It was originally scheduled for June 16th, but then it was pushed back. According to Cahill, the judge that we spent a lot of time watching, prosecutors have proven beyond a reasonable doubt that Chauvin abused a position of authority, right? He was a police officer. He treated Floyd with particular cruelty, and children were present during the commission of the offense. And so all of these things are going to be aggravating factors. They're also saying that he committed the crime as part of a group. They say here it was particularly cruel to kill George Floyd slowly by preventing his ability to breathe when Mr. Floyd already made clear he was having trouble breathing. The motion said on the cruelty factor. And so the way that this works is, let me give you the high-level overview on some of this stuff. So when you are talking about sentencing, I want to show you a chart here in a second. But before we get there, let me give you the high-level stuff. So let's say, for example, you're charged with a Class 4 felony. So in Arizona, we have 6 different scales, or 6 different numbers of felonies. Class 1 all the way down to Class 6. Class 1 is going to be the most serious for a crime like murder. Class 2 is sort of less severe crimes like rape, sexual assault, and those types of things. Then we work our way down. So let's say that you're Derek Chauvin and you're charged with a Class 2 or whatever the equivalent is here of whatever he was charged with in Minnesota. We have different criminal law statutes, so it's different. But let's say he was charged with a Class 2 felony for unintentional manslaughter or murder, which he was convicted of there. Well, what we would do in Arizona is we would look at what are called sentencing charts. And so we would literally open up a sentencing packet that has all of these different spreadsheets in it. And you would just look on the chart and you would say, okay, Class 2 felony. You go down the column, Class 2, you go over, and you've got these different categories of offenses. You've got Category 1, 2, and 3, and so on. And this is kind of the same structure, the same scheme that you'll see in many other states throughout the country. You're basically looking at charts. And so when you are navigating down and you're sort of going down the column and then scrolling over on the chart, you're going to see what's called a presumptive term. And this is where people were sort of kicking around the idea for Derek Chauvin, 10 to 12 years, 12 to 15 years, because they're looking at the charts. They're looking at the scale and they can say, all right, well, based on the factors that we have identified thus far, he falls in this box. Now, what is happening now is the government is saying, well, that box is not appropriate. That's just the presumption. That's where we all start. We know it's a Class 2. We know he doesn't have any prior felony convictions. We know, all the facts and the pertinent details of the case. And so when we go through our spreadsheets and find where to put that pin in the chart, we're looking at the presumption. Everybody starts right there based on the factors. But the government came in and said, yeah, but that's not enough. there are a lot more important things that happen here that are called aggravating factors, right? He was cruel to him. He did this in front of children. There were other people. He did this as part of a group, right? So it was more heinous because it was sort of a gang activity. Well, all of those things are aggravating factors. And so it's going to take it out of that box that is the presumption right there in the middle, and it's going to move it towards a higher, more severe sentence. That's the government's job. They're ramming it that way to make it more severe. It's cruel, children are around, did it as part of a group. Okay, got that. The defense now, they're arguing the other direction. So they're going to come back with a bunch of or they did, the judge didn't buy any of it, mitigation that sort of goes the other direction. Well, he's never been convicted of anything. Well, he's a family man. Well, he, was relying on training. He had a long history serving his community as a police officer, blah, 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 blah. Then what the judge does is weighs both factors. The government submitted all these aggravating factors. The defense submitted all these mitigating factors, and the judge needs to split it and sort of decide, well, this is what applies. And Judge Cahill did and found that all of those aggravating factors, or a lot of them, applied. He said it was particularly cruel to kill Mr. Floyd when he was already having trouble breathing. He also says the victim, being particularly vulnerable, was not proven beyond a reasonable doubt. So 4 out of the 5 aggravating factors brought before the judge were found to be proven. It means the judge could go with a longer sentence for Chauvin than the sentencing guidelines would indicate, which would be a minimum of 12 and a half years. In early May, defense attorney Eric Nelson filed a motion for a new trial, stating that the court violated Chauvin's constitutional rights for several reasons, including not allowing the trial to move outside of Hennepin County and not sequestering the jury the entirety of the case. He also says the jury committed misconduct and wants a hearing to throw out the verdict. So you can see over here from a couple people over on Twitter said, breaking, court finds multiple aggravated sentencing factors in the Derek Chauvin case. He abused a position of authority, number 1, treated George Floyd with cruelty, number 2, children were present, number 3, committed the crime with a group with the participation of at least 3 other people, which is number 4, which were the other officers, right? And he says, bottom line, finding 4 of the 5 aggravating factors mean the judge can sentence him to more than the guideline of 12 and a half years. So you can see that this stuff it can sort of start compounding quickly. I want to see if I can pull up a link here for you that shows you what the sentencing guidelines actually look like, because it is a big, big document. So this is over from the Minneapolis criminal statutes. I didn't pull this up before I started recording. My apologies. But let's take a quick look at this. So the Minnesota sentencing guidelines, along with commentary, and this is a big document. Look, 147 pages. So I just wanted to scroll through this and show you kind of what they're all taking a look at. Sentencing guidelines, commission. We have determining presumptive sentences. So they're looking at things like the offense severity, the criminal history, the presumptive sentence. Where do you all start, right? Where does everybody start? You start at the presumptive, and you can just see we're going to work our way down. Let's see if we can find any charts maybe that will give us some guidance or give us some here we go, severity level of a conviction offense. So you see here, Minnesota statute requires the guideline provide for a range of sentences that are presumptive. The minimum sentence can't be less. The maximum sentence can't be more. Okay, so you just see how this works. It's complicated stuff. So you can spend a lot of time sort of kicking these rules around. So the prosecution can come in and say, well, we think that the criminal history score is higher or lower, and then they can just, bounce around these charts. This is literally what we're talking about. They just go down these charts. This is even more complicated and convoluted than Arizona's. We have a lot of this, but we sort of have it organized, I think, in a better way personally. But maybe I'm not familiar with this document. But you can see, right, 147 pages for sort of navigating these sentencing rules, sentencing worksheet, sentencing guidelines. There's a lot going on there. So the judge ultimately came out, went through everything, and said, here's what we find. This is our verdict and findings of fact regarding the aggravated sentencing factors. And this, again, we know this court very well. We've spent a lot of time here. Says that the court, acting as the trier of fact with regard to sentencing facts, finds the following facts support an aggravated durational departure. They have been proven beyond a reasonable doubt. So, of course, as we know, May 25th, he was employed as a police officer in full uniform, and he used a restraint that the jury determined ultimately caused Floyd's death. So you may disagree with this, but the jury says this happened. Right? And the judge has to go on that basis. The judge can't sort of take what the jury listened to and throw that out. They could, theoretically, but they didn't in this case. So they're going to be leaning on the jury verdict. And the jury said that Derek Chauvin killed George Floyd. So on that basis, the judge has to then apply additional facts to that finding. As a police officer, the defendant, Derek Chauvin, had a position of trust and authority with the community. The trust placed in the defendant included trust that anyone arrested would be treated with respect and only with reasonable force. Defendant abused his position of authority by using force that the jury has determined in returning its verdicts exceeded the authority granted by the peace officers. So the judge is really connecting this back to the jury verdict. Specifically, the defendant with two other officers held Floyd in a handcuffed position with a knee on the neck, prolonged period of time, 6.5 minutes, informed the restraint. Not only was a danger to asphyxia theoretical, it was communicated to the defendant because George Floyd because it was actually occurring. Basically, George Floyd was complaining that he couldn't breathe, and we know that Derek Chauvin heard that. When it became clear, even to bystanders, that he was in medical distress, was no longer responsive, and had ceased breathing, defendant further abused his position of trust and authority by not rendering aid, by declining 2 suggestions from one of his fellow officers to place Floyd on his side, and by preventing bystanders, including an off-duty Minneapolis firefighter, from assisting. I'm not so sure that I agree with that particular point there. Yes, what Chauvin did, of course, was not humanitarian, right? He could have handled the situation much differently, but I don't know that the fact that you have an officer not allowing Genevieve Hansen, the firefighter, to come in and perform resuscitation or provide medical services, that does not seem inappropriate to me, right? He didn't know who she was. She wasn't in uniform. She wasn't part of the official response in any way, shape, or form that I recall. So I'm not so sure why an officer in the performance of official duties would just say, oh, you're a medical person? Let me just come on in here and help me secure the scene. So I'm not sure that I really, buy that. But on the opposite side of that, yeah, there's a lot that Chauvin could have done that would have been a little bit more sympathetic, empathetic to Floyd's situation. The judge says failure to render aid became particularly abusive after Floyd had passed out and while still being restrained in the prone position. One knee, 2.5 minutes, was unable to detect the pulse. So we know all of that. The use of the knee on the back while restraining a suspect was not part of any training by the Minneapolis Police Department. The placement of the knee on the back was an egregious abuse of authority to subdue and restrain Floyd, because he'd already been handcuffed for more than 4.5 minutes. So we've got that. So that was all part of subsection 1, that he abused a position of trust and authority. Then we move into the second prong. We've got also treated Floyd with particular cruelty. So same stuff in paragraph 1. We also know that they're saying that it was particularly cruel to kill Floyd slowly by preventing his ability to breathe, when Mr. Floyd already made clear he was having trouble breathing. Yeah, I know. That one, I know. The slow death of George Floyd occurring over 6 minutes because of his positional asphyxia was particularly cruel because Floyd was begging for his life and obviously was terrified by the knowledge that he was likely to die, but during which the defendant objectively remained indifferent to Mr. Floyd's pleas. Yeah, but he was complaining about not being able to breathe before he was even on the ground. He was complaining in the back of the squad car. So was he having trouble breathing then? And if so, what was causing that? Because nobody was on his neck or his back at that moment in time. Subsection D, restraining an individual in the prone position against a hard street, all while holding handcuffs arms for more than 9 minutes, is a particularly cruel act. Prolonged nature of the asphyxiation was by itself particularly cruel. All right, next we have children were at the scene, and we know that because we saw some of that. We heard some of the testimony that came out. Actually, some of the very first people were underage, right? And they, 14, 12 maybe, they brought him in, and their testimony was powerful. And we know that because the juror who was ultimately excused, who was the alternate, didn't make it into the deliberation room. She said so. We went through her notes. Remember that juror? And she said, gosh, 14-year-old girl was crying. I felt that. That's all you need. If a juror said, oh my God, this person is causing a 14-year-old to cry, it's powerful. You can bring in all the, nanograms per milliliter and all this stuff of fentanyl. Nobody cares because there's a 14-year-old girl crying right in front of you. Children were present, standing only a few feet from where the defendant and other officers were restraining George Floyd in the street. Observed Mr. Floyd being asphyxiated as he begged for his life. 3 were 17 and 1 was 9 years old. Although these 4 children did not observe all the events, they did observe a substantial portion of Chauvin's use of force. And then we also have he committed the crime with active participation of at least 3 other persons. And so this type of stuff is supposed to be, to stop sort of the dog piles that happen. You got a group of guys who were all sort of, kicking the crap out of somebody. Well, they were, it was like a gang ordeal type of a situation. And so, yeah, you were engaged in a situation that was a dog pile, and you need to be penalized more for that because that is obviously unfair. If it's you on a one-on-one situation, all right, that's okay. But if it's a 4-on-1, like in this case, you plus 3 other people, well, that's just totally unreasonable. And because you are so unreasonable, we're going to add aggravating factors. That's kind of the theory here. Well, in this case, yeah, there were 4 people. They were all cops. Officers Lane and Kung were actively involved in the restraint of George Floyd that ultimately resulted in his death. Officer Thao was also keeping bystanders away, and there were even other officers there. Remember, there was the other officer who was securing Floyd's vehicle. No finding is made as to whether the active participation of officers was accompanied by intent or knowledge to establish that they are offenders subject to criminal liability. While they're being charged, and you better believe the government's going to ask for aggravating factors when they come down. So, and this was another point in the trial. It's like if Derek Chauvin was acting so recklessly, if he was doing things that any officer would go, no, that's crazy. You can't do that. Well, why were there like 4 or 5 other officers there at the scene who didn't knock him off or say, hey, stop this? There was the other officer who said maybe we should roll him over, flip him over, but nothing worth justifying anything, further on that. Just say, no, he's good right here. We're going to keep him right here. All right. Sounds good. So you've got 3 other officers who were specifically there. The other officer who went and covered Floyd's vehicle, and there were, other officers shortly thereafter, and nobody saw a problem with it. Except now. Now they all see a problem with it. So the court, acting as the trier of fact with regard to sentencing, also finds that the government has not proven beyond a reasonable doubt that the victim was particularly vulnerable. So what they're saying here is that Floyd was handcuffed, and because you were sort of injuring a handcuffed person, that makes them extra vulnerable. And you get additional penalties for that. If you are restraining somebody and then beating them, well, that is very cruel, right? It's very sort of inhumane to do that, and they will penalize you for that. So here they're saying, well, he was particularly vulnerable because he couldn't even defend himself, and you were basically killing him when his hands were behind his back in handcuffs. So they're saying, well, judge says, although he was handcuffs, he had still been able to resist the arrest and prevent 3 officers from seating him in a squad car before he was placed in the prone position. So that by itself did not create a particular vulnerability. In this case, the drug intoxication did not also render him particularly vulnerable compared to other victims of murder. So, of course, the judge is not taking any of the drugs into account here. Restraining Floyd in the prone position with the weight of 3 police officers on him for a prolonged period of time also did not create a vulnerability that was exploited to cause death. It was the actual mechanism causing death. Signed off on by Judge Peter Cahill. So that means, folks, that the sentencing that Chauvin's going to be facing is likely to be substantial. Okay, 4 out of 5 aggravating factors. It's a lot. That sentencing has been pushed back. As we know, this is a screenshot from the court docket to Friday, June 25th at 1:30 p.m. And if you look over at the documents over there, you'll see that it's going to be a frenzy. Okay, a lot of media requests. A lot of people are going to be very happy about this. Sentencing day, you're going to see people doing cartwheels in the streets. Yeah, racial justice finally in America. Right? We'll see. Well, let's take some questions over from watchingthewatchers.locals.com. We've got Trow Pat in the house. What's up, Trow Pat? Welcome to the community. Says, with all of the evidence and testimony from the first trial being available to literally everyone, how would an appeal second trial work? Is it possible? Yeah, it's absolutely possible. The same thing. It would be the same thing. Now, they could change it, right? Now, they could change their themes. They could change their strategies. They could adjust it, right? You sort of redisclose a bunch of stuff and make some maneuvers. But yeah, when the judge remands it for a new trial, it's a new trial. And so they have to go through jury selection again. Everything we went through, they got to do the whole thing again, if that does in fact happen. Now, this one was a little bit unique because you're right, we all heard everything. So the defense is going to know exactly what Dr. Tobin said. And they would have a second crack at hopefully being more prepared because he, in my opinion, obliterated their case. Was very much the reason why I think that Chauvin was convicted, because of that testimony. Well, now they know it. They know what his game plan is. They know what his PowerPoint slides look like. They know what his little graphics and images look like. So they can prepare a response to that. And the government can do the same thing. They can bring in another Tobin, right? And beef his stuff, add some more PowerPoint slides in there, see how it works. So it is not ideal, right? You want to get it right the first time. And that's why everybody was sort of scratching their heads about a lot of the decisions that were made by Cahill and the court to not do certain things like change venue or even continue the case back. Even just keep continuing it. Continue it for another 12 months, just like what's happening out of Parkland, right? That happened in 2018. That trial still hasn't happened. So there's no real necessity to hurry a trial through in a situation like this. Now, that's not necessarily good for the defendants either, because justice delayed is justice denied. They want a close, a reasonable outcome. And of course, Derek Chauvin doesn't want this hanging over his head for 3 or 4 years either. And he's got the right to a speedy trial. So we're balancing a lot of these different issues. But the last thing that anybody wants to do is to have this happen again, which is why people are not happy with Brandon Mitchell, juror number 52, who may have blown the whole thing. Jeremy Matrida in the House says, does this mean the judge denied the mistrial? So I'm not sure that I've seen a ruling on that one way or the other. The judge is probably going to deny the mistrial, and they're probably going to appeal it. And I'm not sure where we're at procedurally with the appeal, Jeremy, but I have not seen anything about that. I know that the defense submitted their notice of motions, and that's the last I saw. The last thing I saw on the docket was a lot of the media submissions until this recent order came down from Cahill. We have LT13 in the House. Does this give any insight into how the appeal will go? Will he punt? So I don't know that this does give any insight into that. I don't think that Judge Cahill is going to do anything to sort of undo anything that came out of the trial. I think he's going to just try to button this thing up and move past it, and he's going to let the Court of Appeals and then ultimately the Supreme Court deal with it. Now, I don't think, again, that this has anything to there's nothing to glean from this opinion, I think, on the next level, because what's happening here is Cahill is keeping this very closed, a very closed universe. He's not looking into Juror 52. He's not looking into Maxine Waters or the settlement agreement or the lack of not changing venue. He's not looking at any of that. He's just saying, okay, listen, here's what we got. We had a trial. We're going to close this universe, and we know that the jury came back, and this is what they said happened. There's enough evidence that we can convict him on all 3 counts. And that's it. The judge is basically stopping there. The inquiry is not going any further. So based on that information, juror number 52, Brandon Mitchell, any mistrial, appeals, post-conviction relief, any of that stuff, it's a whole separate issue. We're just talking about somebody, Derek Chauvin or any other defendant, was convicted on 3 counts. We know what the charges are. We know that there are these aggravating factors. That's all that the judge is answering here. And we're going to get more information about the other stuff later. I really don't think you should read anything into it, in particular, because I just don't get that from Cahill. I don't think that he would be trying to slide in a hint there. I really think that he wants to be done with this and let the Court of Appeals deal with it. We have Sharon Quinney in the House. Says, wait a minute here. I don't think Chauvin got a fair trial. So how does this work? When do they get to a new trial? Well, they got to appeal it, right? They've got to find a basis for the new trial. They have to, take it up, and the court would have to remand it for a new trial. They're not just going to give him a second shot at it. He's got a pretty big hurdle in convincing the courts that is necessary, because as far as Cahill, in my opinion, he's going to come back out and say, nope, it's all good. Everything went fine here. And if you got a problem with that, take it up to the next level. LT13 says, if I were a police officer, I wouldn't arrest anyone, chase anyone, or get involved in any medical emergency. One bad angle viral video and your life is over. Yeah, I know, man. I know. When we sort of talked to Officer Tatum about that here on YouTube, I think a week or two ago, and he's, officers are feeling depressed. Police went from being sort of this heroic profession where everything that a cop did was saving America to this. Now every single cop who even looks at you is a racist neo-Nazi or something, neither one of those made sense to me. But I agree, right? If you're in a profession that nobody appreciates the work that you do, find a different profession. I know it's easier to say that than it is to really do that, but long term, I'm talking 20 years from now, 30 years from now, right? Why would little Johnny, who 20 years ago said, I want to be a police officer, Mommy, and I want to go serve and protect my community. Well, now little Johnny's growing up and he's looking around and nobody wants to be a police officer. They are sort of the worst, sort of public servant that exists right now. Everybody's angry at them. Not me, but a lot of other people are. And they're just sort of on the receiving end of a brunt of a lot of pent up anger in America. And I don't think fairly. Quite frankly, I don't think that the police are responsible for every single racial infraction that's ever happened in this country, but there are certain contingents on the other side that want to make it about that. And they have said so, that they need to defund the entire police because it is part of systemic racism that is inherently intertwined with the founding of America. And I'm not making that up. That's on BLM's demands on their own website. So you can go take a look at that. We have Osak71 in the house. Says, Rob, big fan. I'm a big fan of you, Osak. So do you think that Chauvin mitigating will offset his aggravation in sentencing? Well, no, I don't, because the judge already just came out. So I think I was a little bit inartful on that. The judge has weighed everything and came out and made a decision. So we now know that 4 out of the 5 aggravating factors are on the record. The judge found that those did exist. So the judge would have weighed everything and come back, and this is the ultimate conclusion. We have Ghost Gunner in the house. What's up, Ghost Gunner? Says, what are the chances this gets appealed based on all the things that could have been corrupted the jury, along with a clearly biased juror? So I think 100%, if I had to say. It is going to be appealed. There will be many, many appeals and probably several appeals, and post-conviction reliefs. I mean, the litigation component of this is not over by any stretch of the imagination. And I think for good reason, because there are a lot of issues that took place here. And we've talked about that a lot. We've had Viva and Barnes on and other people sort of beating the Chauvin issues to death, but there were a lot of them that I think justify further inquiry for sure. Next up, we got, additionally, do you think that Judge Cahill might be irritated with him being named in the appeal and taking it out on Chauvin by enforcing the aggravated factors? Ooh, that's a very interesting observation there. I'd like to think he's not. He seemed fair during the trial. Yeah, I think I agree with you. I've been in enough courtrooms that you can sort of tell certain judges, they get seasoned enough that they sort of, nothing really bothers them. And I got that sense from Cahill. You could just sort of see by the way that he carried himself that there was not much that was going to flap him. He was unflappable. There was one situation where he scolded the Genevieve Hansen, I think the firefighter, kind of scolded her, but it wasn't, he never lost his cool. It was like, all right, I'm a judge. I got to scold this witness because she's not behaving. Let me turn this on for a minute. Put the angry judge hat on. All right, put the angry judge hat on. Now I'm an angry judge. All right, and then take the hat off, go back, whatever, right? It doesn't even matter because you've been doing it for 45 years. It's like just, changing, refilling your cup of coffee. That's how routine it is for judges. And that's the same sort of observation that I got from Cahill. I did not think that he was somebody who took almost anything personally. He just kind of wanted to run an even-keeled courtroom. I think that Nelson could come out and say Cahill was the biggest, awful, biggest, piece of garbage judge he's ever seen. Cahill's going to go, well, it's fine. I've been called that for the last 30 years. So whatever. And I just don't think when you've been doing it for that long that it is as personal as it might look, right? And you're making a good point here, Ghost Gunner, that you could easily expect human beings to act like human beings, and that includes judges. And there are many instances when judges do that. When judges, I know judges here in Arizona, I go, oh gosh, we do not want to be in sentencing in front of this judge because this judge is just not friendly for you or your demographic or whatever. But I just didn't get that from Cahill, and I know that is kind of speculative and not really based in much other than my gut instinct, but that's all I got. We have No Doubt says, after watching the complete trial, the prosecution did not prove he was guilty of any of the murder charges beyond a reasonable doubt. However, I did find him guilty of cruel and unusual punishment, though he wasn't charged with that. We need a set of laws that deal with official oppression rather than just a broad category that police officers and other government officials are subject to. Yeah, so what you're kind of talking about there, No Doubt, are lesser included offenses, and the government didn't include anything less, right, strategically, because they wanted to make sure they got convictions on the murder charges. If they would have included some of those lesser offenses, the theory from a prosecution perspective is that you would be giving the jurors an option of picking something less. They don't want to give them that option. They want to convict on the most serious charges. What's up? Liberty or Death in the house says, hopefully the public doesn't see this for the other 3 officers. First, the DOJ broadcasts they have been indicted. Now they were part of a group that killed Floyd. Do you think the judge will grant a change of venue for the other 3? Uh, it's hard to say yes, right? What if they do? I don't think so. I think they have to say no, because if they do change venue, well, why didn't they do it for Chauvin then, which was obviously the bigger case? So I think as a matter of consistency, they can't change venue now. They got it. Nope. It was fine to do it here in Minneapolis when we did it with Chauvin. It's going to be fine to do it with the other officers. Otherwise, if they say, oh my gosh, yeah, that was a disaster. Yeah, we held Chauvin's trial here. It was a friggin' nightmare. We had Maxine Waters coming in here, lighting buildings on fire. Not that she did that. And then we're going to change it? All you do is that at that point is then open the door for Eric Nelson to come in and say, see, we told you so, jerks. We told you we needed to move this thing. You didn't do it. Now you're doing it. You should have done it for Chauvin. Now I'm asking you to do it so that we can have a new trial that is in fact fair and impartial. Just that would be my instinct on it. Jeremy Matrita says, nothing about this trial was based in fact. I have no faith in our current justice system. Ugh. I know. To what end does this meet by crucifying 4 police officers? To what end does this meet by crucifying 4 police officers for doing their job? Well, Jeremy, it makes a certain segment of this country feel good. I think that's all it does. I mean, I don't know what else it does, because it's not going to change anything in the justice system. What's Minneapolis going to do? They're going to defund the police by $8 million. Then they bring it back, I think, another $6 million. We just talked to Ricada Law here on Monday, and he's saying that some of the external police departments are just not going to go in and support some of the inner city police departments, and that there's this sort of division that's going on. So is justice improving? We're talking about defunding the police now. Is the George Floyd bill going to pass? It doesn't do anything for anything. We've gone through that bill. So what's going to happen here? We're going to have 4 officers who just go to prison, go to custody, and we're going to have a family that gets $27 million. You're going to have a lot of people that make a lot of money and make names for themselves by starting podcasts and writing books and fighting for some sort of cause that doesn't really do much of anything. We went through the demands that BLM has. What are they? They want Donald Trump off the internet, and they want to defund the police. So, okay. So they've got a lot of momentum here as a result of this Chauvin verdict. What are they going to put it to? What is going to go to good use for anything? I read through the 7 demands on the show. I can't see anything that's going to be useful for real justice reform in this country other than defunding the police. So they want no police. That's a good starting point. So what's going to happen? Nothing. But a lot of people in the media are happy about this. And a lot of people just kind of got that, it's kind of like the Colosseum. I mean, really, when you think about it, back in the Roman days, we used to have over there in Rome, they used to have these battles where gladiators would go in, lions, tigers, bears, oh my, and they would kill each other. It would be public sport because people wanted blood. They didn't like their lives. They didn't like what they've been being told. They don't like this idea that America is a certain way, and so they want blood now. And how are they going to get it? Well, it's going to come out of the court of law. It's going to come out of Derek Chauvin and these 4 officers, because where else can it come from? It's not going to come from our politicians. We've had the same stinking politicians my entire time practicing law promising us all these changes. Oh, we're going to improve this, and we need a committee, and we need a research team over here, and we're going to go talk and do some community policing and go interface with the little people down there that we're patrolling. All right. Anything changed? No. Any real meaningful reforms across any part of the country? Not that I have seen, truly. I mean, it's more of the same crap. Every time the police kill some black kid, it's the same garbage. The mayors stand up, the governors stand up, all the senators stand up. They go, up. This is just awful. We're better than this. We can do more in America to stop this from happening. And then what happens? Nothing happens. Nothing. We have a trial. Cops go to jail, and it's just status quo moving forward. Joe Biden comes out, addresses the country, talks about it for like 15 seconds, and then mentions pass the George Floyd bill. That's it, right? Are we expecting anything from him? No. He's got 30 years of criminal justice ear reform, of slamming people behind bars and throwing them in custody for 30 years. And his VP is Kamala Harris. So somehow, some segment of this country thought that these 2 knuckleheads were going to be the saviors of our justice system. Give me a break. It could not be possibly worse. But still, they are getting a lot of the benefits because they have everybody in their pocket. They've got all the media, all of the politicians. Nobody wants to stand up for any of this stuff. And what happens? The people suffer. Government does fine. Everybody else who's on the receiving end of, bad policing and now rioting, we're all suffering the consequences because the police aren't going to want to go in and clean up the streets. And we kind of need them to do that now, because if they're not doing it, who's going to handle it? BLM? Thank you for that, Jeremy. Joe Snow is next. We've got, listen, I don't know where I am or what position I'm being detained in. If I'm in handcuffs and I tell the police I can't breathe, I need medical. Yeah. So did George Floyd, evidently. We have Sharon Quidney says, how can a law enforcement officer be held responsible for the presence of children? Should they change their tactics just because kids can see what's going on? And where were the parents? Doesn't make any sense to me at all. Yeah, so that is interesting, right? Because these are aggravating factors that are usually for defendants, right? This is usually for, the guy who's beating his wife in front of his kids in their, apartment building. That's what this is for. It's not for an officer arresting somebody and 3 other cops were there. They're sort of not written for that. All right. We have next up, we've got Liberty or Death says, pretend this happened in AZ and you were counselor. What is the procedure that you would follow and your next steps? Well, sentencing is what we would be doing. So in Arizona, the way that this would work is we have sentencing. So Chauvin would be going over and he would be going and having what's called a pre-sentencing report that would be done here by the Maricopa County Probation Department, essentially. And they would be sitting down with him and they would be doing an interview with him. At this point in time, we'd also be working with a mitigation specialist, somebody that is only focused on mitigation. That probably would have started a long time ago, but they would also be working on the case. We would be preparing to go down and be there, a part of the pre-sentence interview. We'd probably have a sentencing court date that would be scheduled, and very, very unlikely that there would be sentencing that would take place at that time. What we would probably want to do is go there and then have probably a meeting in chambers with the court. Probably what they're going to do here in this case, talk to the judge, talk to the prosecution, talk to the probation department, figure out kind of what everybody's asking for. When it comes to sentencing, so here's the way that it works. You'll have the defense is going to come out and make their offer. The prosecution is going to make their offer. And then you're going to have sort of what's supposed to be an impartial, unbiased analysis that is typically done by a third party. In this case, it's the court or it's the probation department or an extension of the court that is more under their arm, not the prosecution's arm. So you're going to have 3 different reports kind of coming in there, skidding in there, sentencing recommendations and so on. All of those come skidding in. Once they're all prepared at the sentencing court date, you're probably not going to sentence in that date because you're just going to be getting a lot of this information. So you're going to ask for a continuance or an extension, or what we call them our mitigation hearings, further down the road. Then you can sort of reconvene, come back, and have a powerful sentencing. Bring in everybody, right? And if you're Derek Chauvin, at this case, you're bringing in everybody, wife, kids, family, every single human being to come in and talk about, what a great person he is, other fellow officers, and you try to cram in as much as you humanly can for the courts. So that's what we would be preparing for. Also, I don't do appeals truly, so we would be working with an appeals attorney and a post-conviction relief attorney. I mean, I don't do the appeals. We do that here at the firm, but I don't personally do them or have much experience with them. That's for the people who love to write and read and research and just read and read and read and write and write and write and write. And I don't have. I'm well capable of doing that. I just prefer to come rant here on YouTube. So it's a good question, Liberty. There's a lot going on there. We have next up, last one on this segment, comes from Software Nugget. Says Chauvin is definitely innocent. The prosecution didn't make their case, but a lot of people think that you're a horrible person for thinking that. But Chauvin was simply doing his job. Yeah, and Software Nugget, my perspective on this has always been that the beyond a reasonable doubt standard just wasn't met. I think that there was plenty of reasonable doubt in this case. I am not endorsing anything that Chauvin did, right? I've said for a long time, I agree with the witness who called him a punk. I think he is a punk. I've seen many officers like this who just think that they have unlimited power and that they can go do whatever they want. I'm not excusing anything that Chauvin did. But the government still has to meet their burden, and they got to prove him guilty beyond a reasonable doubt. And when I looked at the case, fentanyl, methamphetamines, last-minute drug ingestion at the scene, hypothetically. We've also got the 2019 case where his blood pressure was like 216 over 160, something insane. And the list goes on and on. Plenty of reasonable doubt. The government's own witnesses said that if they would have walked into his apartment and found him dead, they could have attributed it to a number of different causes. Either the fentanyl independently by itself could have done it, or his heart condition could have done it. 90% clogged arteries out of his arterial sclerosis and hypertension. So plenty of reasonable doubt there. All right. Great questions. Thank you so much for those. Those all came over from watchingthewatchers.locals.com. And we really appreciate your support. We've got a lot of good events coming up over there, and I'm excited about that platform and where it's going. So thanks for supporting us over there. All right, so we are now going to change gears, and we have to talk about it. The N-word is something we have to talk about today. Not the actual word, just the N-word. Brace yourselves now. This is a touchy subject, right? This is a complicated area of the law because it invokes a lot of emotion. Anytime you hear that word, you go, oh my gosh, that is the worst word in the English language, and it needs to be eradicated from our vocabulary, and I don't disagree with that. But unfortunately, some people still use it, and there are some statutes that are in existence in America that make that type of language criminal. And so the question we have to ask ourselves is that in fact criminal? Is it a crime then to call somebody that, or to use that word, to use the N-word? And, you know, this reminded me when I was thinking about this segment that I have to do on here, I'm thinking, oh gosh, there was a Louis C.K. clip, and I know, you know, after his whole Me Too movement thing, but he still had a great joke talking about that, the N-word, right? And he doesn't use it either, and nobody should, but he says specifically, the people who say that, they are total jerks because they're making you think the word in your head every time they say the N-word. So I apologize in advance for that, but I just don't know how else to cover this because here's the headline. It says, federal court saying the N-word to two black people does not qualify as fighting words. What? Because it kind of sounds like it might. Story was posted over at lawandcrime.com from Colin Kalmbacher. It says, flinging the N-word does not necessarily fall under the fighting words exception to the First Amendment, federal court found on Tuesday. Case is U.S. versus Bartow, U.S. Court of Appeals, Fourth Circuit opined that the N-word is, quote, an ugly racial epithet and a highly offensive slur that undoubtedly constitutes extremely abusive language, but determined that the slur cannot broadly be criminalized under the nation's current free speech regime. The case centers on retired Air Force Lieutenant Jules Bartow, who was convicted under Virginia's abusive language statute for a series of increasingly offensive rhetorical questions that came to include the N-word as he was talking with a sales associate while shopping for boots at Quantico Marine Corps Exchange. Bartow is white, okay, the person who is being charged with the crime here. The sales associate, he was intent on verbally upsetting. Kathy Johnson Felder is black. So we have a retired United States Air Force lieutenant goes into a store, wants to buy some boots, gets into it with a woman named Kathy and starts to use some language. And then eventually in this conversation, the N-word comes out, and now cops come. He is arrested and charged with a crime. He's actually charged with a Virginia abusive language statute violation, and he takes this up, right? He said, no, you can't do that. I have free speech in this country. I'm allowed to use that language if I want to. Government says, no, hold on a minute. You have free speech, certainly, but not fighting words. You know, you can't just go up to somebody and start lobbing insults in their face, sort of intending to provoke an attack out of them. And then when they attack you, say, but my free speech. That's not how that works, right? We know that as people that words can be extremely volatile and very provocative and encourage people to respond accordingly. So the Supreme Court has said, well, free speech doesn't apply to that. You can't go out, walk up to somebody and say, your mother, and expect them to not respond. So that is being carved out. But what about this case? What about the N-word? That is, if there are any fighting words out there, that's one of them, right? Diana Gribben-Motz, the circuit judge, drafts this opinion, says, Jules Bartow, so this is the Army lieutenant, challenges his conviction for using abusive language in violation of Virginia law. The First Amendment permits criminalization of, quote, abusive language, but only if the government proves the language had a direct tendency to cause immediate acts of violence by the person to whom individually it was addressed. Okay? So to whom individually it was addressed. The direct tendency. So if I'm going to say that to you, does it have the direct tendency to cause you, not a random person, you, the person I'm addressing it to engage in immediate acts of violence? The ugly racial epithet used by Bartow undoubtedly constituted extremely, quote, abusive language, right? Part of the not legal language. But because the government failed to prove or even to offer evidence that Bartow's use of highly offensive slur tended to cause immediate acts of violence by anyone, his conviction cannot stand. So you see what they did? They're just taking this. They're saying abusive language is not permitted if it causes immediate acts of violence by the person to whom it was addressed. So immediate acts of violence. They didn't prove that in this case. So they're saying, yeah, I mean, it was extremely abusive. It's the N-word. It's a terrible word, but they can't show that this would have caused the woman, Kathy, to respond with immediate acts of violence. And so because the government didn't prove that, they're going to send this back down to the lower court to vacate Bartow's conviction and sentence. So he's not going to be, he was convicted of this, right? He was found guilty of using abusive language by using that word. And now they're saying, nope, vacate it. Conviction has been thrown out because it can't be illegal because there's no evidence that there was any immediate acts of violence by the person to whom the word was said. So this all happened, interesting story, this all happened back in November 2018. Retired Air Force Lieutenant Colonel Jules Bardow, who is white, entered Quantico Marine Corps exchange to shop for boots. The entirety of evidence offered by the government to prove its case against Bartow consisted of a store camera video without audio, which is a bummer, of the short encounter at issue here, and the testimony of two store employees as to their recollection of the events. The video lacks audio and individuals move in and out of the frame. It is not possible to determine from the video when Bardow was talking or to whom he was looking at when he did speak. For these reasons, the government has primarily relied on the testimony of its two trial witnesses. So he's in the store, camera's running, but it's not capturing any audio, which is pretty important. So Bardow goes in. First employee, Kathy Johnson Felder, who is African-American, testifies that she approached Bardow and says, "Good morning. May I help you?" And so all this stuff must be coming from the trial record, right? They're going back and said, hey, there was a trial here. What happened? Trial went through. She comes in and testifies. So the Court of Appeals is just looking at the lower level record and saying, okay, well, this is what they said happened. So this is all information that's under oath, and now we can analyze it. Bardow says, Kathy says to Bardow, "Good morning. May I help you?" Bardow responds, "If I had indigestion, diarrhea, or a headache, would you still address me as good morning?" Strange thing to say when you walk into a store. Bardow raised his voice to Kathy, who froze in shock. Kathy again asked Bardow, "Can I help you, sir?" He responded, "I'm not a sir. I'm not a male. I'm not a female. If I had a vagina, would you still call me sir?" Bardow gestured and pointed his finger several times at Kathy, who was a number of steps away from him. She was, quote, taken aback. Bardow raised his voice, and it drew onlookers, including a white uniformed Marine Lieutenant Colonel. The Lieutenant Colonel began a conversation with Bardow, during which both men gestured at one another with pointed fingers. Bardow continued to try on boots throughout this exchange, as did Lieutenant Colonel. As the discussion continued, a few more people gathered around, including an African-American man in civilian clothes. Kathy, the store clerk, related that the civilian explained to Bardow that the reason that the employee at that exchange say, sir or ma'am, is because you're purchasing merchandise on a military installation, right? You're on a military base. So when you go in and buy an item, they welcome in, sir. Welcome in, ma'am. Good evening, sir. Good evening, ma'am. So if somebody goes over there and explains that to Bartow, says, hey, don't give her any grief. What are you talking about? You're on a military installation. Of course we talk that way. You know that. Bardow then responded, says, if I called her an N-word, would she still say good morning? Whoa. So we see where this is going. Okay, so Bardow is just angry, trying to get a rise out of somebody. Kathy's testimony is unclear as to whether she believed this slur was directed to her or to the African-American man in civilian clothes, right? We got a little bit of a problem here. We've got one speaker, we've got two recipients, and we don't know which recipient that language was directed to. In any event, Kathy, the store clerk, who remained several feet away from Bartow, asked another employee to call over Vicky Hurd as store security officer. Hurd, the only other witness called by the government at trial, testified that she was asked to go to the area where shoes were sold to address loud noises and people arguing. When she did so, she also encountered Bartow on the floor trying on shoes and a white lieutenant colonel standing over Bartow and arguing with him. Hurd could not recall exactly what Bartow was saying, but she testified that she did not hear him use the N-word. She did observe, quote, a heated conversation between Bartow and the white lieutenant colonel, who was very animated, pointed his finger at Bartow. Heard moved between the two and told Bardo to put on his shoes and leave the store. She escorted Bardo out, and base security officers arrested him. Bardo pled not guilty to violating Virginia code. Case proceeded to trial before a judge. Following the presentation of the evidence set forth above, the magistrate concluded that Bardo, quote, directed the slur at an African-American man who was talking to him. The judge did not make any findings as to whether the African-American man was in fact likely spurred to immediate violence, okay? And that's the standard. When you receive that conversation, that communication, are you likely spurred to immediate violence? So the judge didn't say anything about that, or as to the likelihood of such a response from an individual in the man's position. The magistrate found Bardo guilty, fined him $500, the maximum penalty under the statute. So it sounds here that they're actually making this more like an objective test. So there's kind of two different ways to analyze this, and I don't practice law in Virginia, so I don't know. But the two different ways of interpreting this, right? One would be that this is a subjective standard. So the idea is that the person to whom you're directing the epithet, it matters whether they would respond with immediate violence, okay? Whether they specifically, that person. If you're threatening me, you say, would Robert Gruler be prompted to action, to immediate violence? Me specifically. Or that's a subjective standard because we want to know about me individually versus an objective standard. Would a reasonable person in that person's position, not Robert Gruler specifically, but somebody in my position, let's say, a 35-year-old attorney in Scottsdale, Arizona. Would a 35-year-old attorney in Scottsdale, Arizona, who's a white guy, who's unmarried, whatever, if somebody uses an epithet towards him, would it prompt that person, who is a reasonable person, who is not Robert Gruler, but somebody like him, to respond with immediate violence? It's a distinction between the two types here. And so this is making it sound like more like it's objective. You can see that because it says whether the man was in fact, whether the African-American man himself was in fact, right, whether he was, or whether the likelihood of such a response from another individual in that man's position. So we don't know because it doesn't really matter because the judge didn't find it either way. Judge didn't say it doesn't matter. Don't know about that guy and don't know about a reasonable person guy either because didn't even analyze it. The magistrate found Bardo guilty, fined him $500, the maximum penalty. On appeal, the district court affirmed the court did not discuss to whom Bardo directed the epithet. The court seemed to rely on the apparent friction between the white lieutenant colonel and Bardo as the basis for concluding that the use of the N-word elicited, quote, an impending breach of the peace. So Bardo appealed and he won, right? Court said no, doesn't count. He's allowed to say those things because we don't know to whom it was directed and whether or not that would have prompted immediate violent action. Let's take a look at the opinion's justification and rationale. We're not going to go through this whole thing, but it says here, the Virginia code that he violated was, this is it specifically, says, if any person shall, in the presence or hearing of another, curse or abuse such other person, or use any violent, abusive language to such person concerning himself or any of his relations, or otherwise use such language under circumstances reasonably calculated to provoke a breach of the peace, he shall be guilty of a Class 3 misdemeanor. Okay, reasonably calculated to provoke a breach of the peace, violent, abusive language. Supreme Court of Virginia has limited that to abusive language that has a direct tendency to cause acts of violence by the person to whom individually the language is addressed. And they're going back to a Virginia Supreme Court case, right? So that makes it sound like it is a subjective test. As such, the statute only criminalizes personal, face-to-face, abusive and insulting language likely to provoke a violent reaction and retaliation, right? And that makes sense. This is different, right, than instant messaging somebody or than text messaging somebody. If you call somebody whatever over a text message, is that going to provoke immediate violence? Maybe, but less likely than it would be if you were in their face, right? Because there's a proximity problem there. They're in your face. You don't want them there anymore. What's one way to do that? Well, it's to get physical. So if you're in person, it sort of increases the stakes a little bit. And the Supreme Court said that that is part of the requirement. Of course, that was applicable here. This narrow construction they have recognized is required to harmonize the statute with the First Amendment's guarantee of free speech. So we're balancing some interests. First Amendment also provides that Congress shall make no law abridging free speech. Government has no power to restrict expression because of its message, its ideas, its subject matter, or its content comes from a U.S. Supreme Court case out of 1972, and they're going to go through a history there. We've got, in 1942, we have another U.S. Supreme Court case called Chaplinsky. The court defined fighting words as words that, quote, by their very utterance inflict injury or tend to incite an immediate breach of peace. Chaplinsky court concluded that resort to epithets or personal abuse is not in any proper sense communication of information or opinion that is safeguarded by the Constitution. So it may be punishable as a criminal act. If this remained the Supreme Court's teaching on the contours of fighting words, Bartow's abhorrent slur would undoubtedly constitute a fighting word punishable as a criminal act. But in the decades since Chaplinsky, the court imposed a number of limitations on the fighting words exceptions. First, the court effectively eliminated the inflict injury prong of fighting words. The government may only criminally prosecute a fighting word speech shown likely to produce a clear and present danger of serious substantive evil that rises above inconvenience, right? And so what the Supreme Court did is they said, yep, fighting words are not protected. Can't do that. And then what happened after that is they have a series of cases that came out after that says, well, that one's protected and that one's protected. And we're going to loosen the standard a little bit. You can see here that they said that only that which has a direct tendency to cause acts of violence. We have number 3. They explain that the small class of fighting words is limited to direct personal insults only, directed to the person of the hearer, okay, actually or likely to be present. So it's not something that is sort of out there in the open, right? I hate, all certain types of this person or whatever. It's directed to somebody specifically. Why? Because we want to prevent the causation of immediate violence. If you're just saying, well, I don't like bananas out there, generally speaking, well, a lot of people don't like bananas, but is that banana right there going to be mad about that? Likely to peel himself and go into a frenzy? Maybe, but if you direct it directly to that one specific banana and you say, you taste terrible, well, he's going to flip out and jump out of his peel. And then we're all going to have to deal with the consequences. Without evidence of a direct personal insult, the court has determined the government may not obtain a conviction for fighting words. Evidence of a direct personal insult. Okay, so you see that? So the standard is tightening up a little bit. They're saying that fighting words are generally excluded, and then they're bringing them all back in because that was too broad. It was too much of an exclusion. Too much free speech was getting caught up in that lower standard, so they needed to raise the standard. Well, we're going to protect that. We're going to protect that. We're going to protect that. And let's continue on. Virginia code requires proof of the abusive language. Then we have, it's hard, they say here, it is hard to think of an English term that is more abhorrent. And we have some different citations here. The N-word is the most noxious racial epithet in contemporary American lexicon. The vile epithet has a unique power to offend and insult and belittle. It is so loaded with a legacy of slavery and racial hatred that it is inextricably linked with prejudice and hostility towards African Americans. And they're going straight to the Oxford English Dictionary. And they got the word written in there. We have here, it says, all the bitter years and insult of America, no other word in the English language so powerfully or instantly calls to mind our country's long and brutal struggle to overcome racism and discrimination against African Americans. But the Virginia statute does not and could not, consistent with the First Amendment, criminalize the mere statement of this word. The government recognizes even the most egregious racial slur is not a fighting word per se. The circumstances in which the word is used matter a great deal. So they go through, they explain it. They say, well, based on this, the government maintains that Bardow addressed the slur to both Kathy and the African-American man in civilian clothes. But the judge found that Bardow directed the slur at the African-American man. District Court did not state to whom it believed the slur was addressed, but it seemed to base it on the reaction of the white lieutenant colonel to Bardow. Parties agree, however, that he was not Bardow's addressee. So nobody knows who he was talking to. Seemed kind of obvious to me, right? He said, well, what if I called her that? But he wasn't actually talking to her. He was talking to the other guy. Everything about Bardow's remarks was offensive and bizarre, the court said. Their meaning was difficult to discern. Bardow suggests in his briefs that his remarks reflect his discomfort with gender labels and sex stereotypes. Oh. He maintains that he used the slur because just like it can be offensive and degrading to be called the N-word, it can be degrading, humiliating, invalidating, and mentally devastating for a transgender person to be misgendered, to be called sir when they are not male, or ma'am when they are not female. Oh, another piece of the puzzle comes into play, doesn't it? Everything about Bardo's remarks were offensive and bizarre. Their meaning was difficult to discern, although now rare criminal convictions for the use of fighting words still are possible, but they require the prosecution to offer compelling evidence that meets all limitations on the fighting words doctrine. Let's see what else we have here. Government offered no similar evidence here. For the foregoing reasons, we reverse the judgment of the district court and remand the case to vacate Bartow's conviction and sentence. In summation, the government has not proven the use of the vile slur was likely to revoke a violent reaction by the person to whom individually it was addressed. The government has not proven that the slur was used as a direct personal insult under Johnson. The government has not proven that the actual circumstances of the use of the slur were particularly conducive to violence. This total lack of evidence requires us to vacate Bardo's conviction. So, probably the right move on that, right? But it's a gray line on that one. But the right call. Err on the side of free speech, not over criminalization. I think it was the right move. Good call for circuit. We have some questions coming in from watchingthewatchers.locals.com. Keep it professional here, folks. John Delar 52 says, black people use the N-word more than whites. What are they going to do? Just use a law against white people? When black people say it's too offensive, but no one cares. Oh, that's a good point, right? And so how do you sort of apply that? So this is a great question that the Supreme Court is having to flesh out. Right? What if somebody just says it, generally speaking? Right? Is that hate speech? Is that a hate crime? Is that something that warrants a criminal charge? I think most of us would say no, but a lot of people would say yes, absolutely. Right? We have a huge segment of this country that thinks that basically, waking up, you are a white supremacist. We've seen that. We've talked about it. We've actually shown the documents that have come out of some of these critical race theorists that just say, well, if you are a white person, you are a part of the problem for everything that you do. E. Dantes is in the house, says, I agree the N-word is an ugly word, but there are other racial slurs for other races that justify a violent response. Maybe there is, I don't know. Can you call someone of Asian descent by a name that counts as fighting words? So yes, I think you can. I mean, I don't think that this court case is saying that the N-word is not fighting words, right? That's not what they're saying at all. They're saying that it absolutely could be fighting words, but it needs to be used appropriately or inappropriately. It needs to be directed in a certain manner that would cause somebody to respond violently. And because in this case it was not, according to the lower court's findings. So remember, the Court of Appeals in this case, they're not going back and doing a new trial. They're just saying, hey, you guys did a trial. Let me just read through what happened in there. All right, I'm flipping through here. Judge did this, cross-exam. All right, got it. Did anybody ask about immediate violence? Did anybody ask about who this was directed to? Because that's required under the law in order for this conviction to stand. Did you do that, Judge? No, you didn't. So got to vacate it. And that's why I think it was the right move. Now, under a different set of facts, right? If Bardow goes in and says directly to Kathy, hey, you are, or something, right? Directs it to her in a way that would provoke immediate violence or an immediate response, or even from a reasonable person, and that was on the record in the lower level court proceedings, then certainly I think this would have gone a different way. It was about the facts of the case, not about the use of the word. We have Sharon Quidney says, AFAM folks call each other the N-word quite a bit. In fact, my African-American friends have called me an N, and I'm white. I guess it depends on the context. I totally have. Yeah, absolutely. I'm pretty hip. So we've got NY Renal MD in the house, says, why is this law needed? It seems completely subjective. What if the retired lieutenant colonel bi-gendered the black saleswoman? Well, that's where this going. That's where this is going. I mean, I know. It's kind of ridiculous, but I know. Sharon Quidney says it's an interesting social interaction because for an African-American friend to call me an N, it's actually kind of a compliment, like you're one of us, right? But to call me a cracker would be an insult and vice versa. So this is interesting from a sociological, linguistic point of view. It is interesting. I still think it is sort of a repulsive word, but there are some sort of colloquial ways of using it. The way that I'm thinking about it right now is from Curb Your Enthusiasm, right? With Larry David, and they adopted a family from Karina, or whatever the theoretical, hypothetical hurricane was on the show. And the family happened to be African American, and their last name was the Blacks. And so Larry David adopted the Blacks from Karina. And, they were using that word all the time on the show. And it was a word of reverence. They were sort of having fun with it. And, when I was the slowest kid on my high school football team who was also a running back. Yeah, I mean, the faster kids who would smoke me off the starting line, we had a relationship. And so, they gave me props for trying my very best as that very slow white kid on the football team, which is why I don't play football and I wrestle, because I don't have to run when I'm wrestling. Next up, we got Liberty or Death says, so was the prosecution arguing that the vast majority of rap music should be banned? I don't know. I mean, I guess, right? If the prosecution thinks that just the mere utterance of the word is enough for criminality without having to prove that there was a causal connection to some sort of immediate harm or immediate violence, that's their standard. NY Renal MD says, so wasn't there a certain controversial protest in Charlottesville, Virginia? I can recall over network TV, very insulting words and assumptions made over the protest for the maintenance of the Civil War statute. Seems like a few people could have been arrested and charged, maybe avoiding the woman who died. The protesters who had a permit were treated very badly by law enforcement. Yeah, I remember the Charlottesville, and I remember the, fine people hoax and all of that stuff. I get all of that. A lot of battle is taking place in the battlefield of language, right? We're seeing this all over the country. People are getting very, very particular about this. And we're even seeing it, in people's Twitter profiles and stuff. I think I saw a headline today. Instagram now, when you sign up for an account, I think they have like 42 different pronouns you can choose from. And we're seeing that this has volatile results. There was the video, I think, from a GameStop store where, a transgender individual walks into a store. The store clerk calls her sir, and she loses it, right? And it causes a scene. And so, people are going to be in these interactions. People are going to use the wrong pronouns. People are going to be highly offended. We're going to see situations like this where apparently Bardell walks in. I don't know if it's a transgender person or not. That footnote maybe leads me to believe that it is. Kind of irrelevant, right? The question here is about the language that's being used and about whether we can criminalize language. I'm on the side of not criminalizing language. You can have very grotesque and awful language, but you don't want to criminalize that, right? We want that out in the open. We want to see who's saying gross, awful things so that we can know not to do business with that person and not to invite them over for dinner and not to be friends with them if they harbor those grotesque beliefs in their minds. But if we criminalize everything and we make it so that people will not share their thoughts or ideas, well, we're going to have a pretty stagnant country of a bunch of monolithic people who are all part of groupthink, all thinking the same way. We want some variety in this country, even if it means we have some ugly things that are a part of that variety. We want more people to express themselves. There's going to be some ugliness in that, but we need to see it rather than suppress it. We have _shade says, didn't know you can take someone to court over words. I do not like that word whatsoever, but also what happened to sticks and stones. Yeah, as your mother told you, sticks and stones may break my bones, but words will never hurt me. Just let it roll off your back, right? It's a good lesson. Now, words are, of course, the subject of lawsuits and courts all the time, right? I mean, we have entire contracts and things that we sign. Words are very important. And so they also apply to criminal law, but you just got to make sure that it is in the context of something that is actually criminal and not just somebody speaking out or blowing off some steam or using something that's very gross language. Gross language is still okay in this country. You're allowed to use racist, awful language for the time being until it's illegal. Currently, it's not. Chris John says, doesn't that ruling have the potential to incite violence? Oh, gosh, that's true. For example, when a recipient who is aware of the ruling hears the N-word and wants the person saying it to be charged, yeah, that's going to cause some incitement. Well, the Fourth Circuit is probably just going to be lumped in with all of the other MAGA people who want to wreck America by inciting violence. I mean, basically everything is incitement of something to some degree, right? We're all part of the problem. Chris John, you're part of it too. We have Be Brave says, it's hard to believe that the courts are having to interpret conversations. No words should be illegal, only socially unacceptable. It's pretty good standard there. I think that I'm closer in alignment with that standard than some of the other ones. Now, if somebody comes up to your face and is screaming at you in the face that you're a this or you're a that, right? You kind of gotta draw the line at some point, or at least, if you sort of respond to that person, you shouldn't be charged with a crime, in my opinion. If you settle that, out in the streets. We don't want that. We don't want any violence. We don't want any fighting. We want polite people in this country. No bad words, no racial epithets, love and harmony and unity. Folks, Joe Biden's president, okay? Unity, America. We just want some more love in our lives. Thanks, Joe. All right. So thank you for those questions over from watchingthewatchers.locals.com. We got one more segment on the show today, and let's get right to it. Ahmaud Arbery and the McMicheals are back in the news. We've been covering this case for some time. Ahmaud Arbery was shot and killed last year by Greg and Travis McMichael. This story has been a very interesting one. If you recall, back when we were originally covering this, there was some question about whether this was sort of being swept under the rug, because the Ahmaud Arbery shooting took place a long time before these two gentlemen were ultimately charged with crimes. And so we're going to give a little bit of an update on this case, break down what actually happened, because they have court today. They had court today and they have court tomorrow. They're scheduled for trial coming up, I think, later at the end of the year. But they are also now fleshing out some motions. They have evidence that they need to get into court or out of court. In particular, a big piece of evidence that's very important for the defense is records of Ahmaud Arbery's past. He's got some prior malfeasance in his history, so the defense wants to bring that into court. This was a situation where allegedly Ahmaud Arbery was running down the street. The McMicheals are saying that they thought that he was stealing from a house, so they chased him down the street. Gregory McMichael was a former police officer. Travis McMichael was his son. They hop in the back of a car. They see this African-American guy running down the street. So they hop in the back of their pickup truck, grab their firearms, chase him down. They go down the street. A neighbor by the name of Roddy Brown, I think, he comes out, and now he is helping to sort of capture this running kid who's running down the street. And so they go down this little bit of a loop-de-loop, and we covered this extensively on this channel. We had maps and we were diagramming the whole scene and everything. So I would encourage you to go watch those videos if you want to check that out. But what ended up happening is Ahmaud Arbery kind of turns around and he's going back and approaching the guys, McMichael, both McMicheals and Roddy. And they come into contact with one another, and Travis McMichael has a shotgun, and Ahmaud Arbery sort of comes to him, right? They come to each other, and the shotgun goes off 3 times, according to Travis. If you're on the other side of this, you say he was shot 3 times. Travis McMichael shot him multiple times after they sort of chased him down. Now, once this caught wind, or this happened, and it didn't catch wind for several months until it sort of leaked out to the media, and then it turned into this big spectacle. The reason it caught my attention is because it really looked like that Travis McMichael, one of the former officers, or a former officer for this particular part of Georgia, may have escaped any criminal liability. We had multiple prosecutors look at this case and say that what happened here was self-defense. Nothing went wrong until the rest of the country saw the footage, and we said, what? That looked like a murder to me. So let's take a quick look. We're going to go through some background here, and we're going to go over to the AP. They say that a judge asked by the defense to okay evidence of Ahmaud Arbery's past troubles. So attorneys for a white father and son, don't you love how that's like the first thing we talk about now? The first thing, a white father and son charged with chasing and killing Ahmaud Arbery asked the judge Wednesday to allow evidence of the slain black man's past problems to be presented when their clients stand trial for murder. Prosecutors argued that Arbery's criminal record and other prior problems should be kept out of the trial, saying they are irrelevant to the defense decision to arm themselves and ultimately shoot a man who was trying to run away, which I actually agree with that. I mean, I think, objectively, if I'm observing this not as a defense attorney, if I'm looking at this like a judge and I have to decide whether to allow this evidence into court or not, I have to ask myself, all right, is this relevant? If Travis and Gregory McMichael chased Ahmaud Arbery down the streets, did they know about his past records? Did they know that he may have had prior shoplifting charges or whatever previously? cause them to act the way they did? I'm going to guess that the answer is no, right? They saw some kid running down the street. That's all the information that they had. So are they going to be able to say, well, the only reason we chased him is because we knew that this was a criminal based on his criminal history? No, some kid running down the street. Allegedly, they thought that there were some shopliftings taking place in the neighborhood, and so they wanted to stop that from happening. That's it. So what if he has all of these other records? Those shouldn't come into court. Travis McMichael and his father, Greg McMichael, pursued the 25-year-old black man in a pickup truck after they spotted him running in their neighborhood on February 23rd. Remember, this was all pre-Floyd. A neighbor, William Roddy Bryan, joined the chase, took the cell phone video of Travis McMichael shooting Arbery 3 times at close range with the shotgun, right? And the original story here was that, the shotgun went off and that Arbery was pulling the gun away from Travis McMichael. He was pulling it. And if you have a finger on the trigger and you pull the shotgun, well, your finger's going to go this way as the gun's going this way. Gun's going to go off. 3 times. Got it. Defense attorneys argued that the 3 men committed no crimes. They say that McMichaels suspected Arbery was a burglar after he'd been recorded by video cameras inside a nearby home under construction. Travis McMichael's lawyers say he shot Arbery in self-defense. Okay, and if you haven't seen this video, I have a clip at the very end that was assembled by the incredible Ma Fox. We have Jason Sheffield, one of Travis McMichael's lawyers, told Superior Court Judge Timothy Walmsley on Wednesday that Arbery's past arrests and other incidents include not only, quote, theft crimes, but also show a pattern that Arbery, when confronted with wrongdoing by police or other authority, would become angry and aggressive physically and verbally. His intent and motive is something that is central to the case, says Sheffield, which I understand. I mean, it's a defense attorney. You have to make that argument, but it's really not, unless the McMichaels knew about that. Did they know about it? Did they have any reason to know about it? Or did they just chase some black kid in the street without any other information? Prosecutor Linda Dunikoski argued that Arbery's past had no bearing on the McMichaels' decision to pursue him with guns because they did not know anything about him prior to the fatal chase. Yeah, exactly. It doesn't matter what Arbery's thoughts were. It doesn't matter what his actions were. He was running away from these men, and he was. Defense attorneys for the McMichaels want the jury to know about 10 incidents from Arbery's past, including that he was on probation at the time he was killed. Arbery pled guilty to charges that he carried a gun onto a high school campus in 2013. A year after he graduated, Rodney Ellis, police chief for Glenn County School System, testified at a hearing on Wednesday that Arbery tried to evade officers on foot and stopped only when 2 of them pointed guns at him. In 2017, court records show Arbery pled guilty to a shoplifting charge for stealing a TV from Walmart. Judge rulings could have a big effect on how this trial plays out. Last week, scheduled jury selection to begin on October 18th in Brunswick, Georgia, 70 miles south of Savannah. All 3 men are charged with malice, murder, and other counts. Case sparked national outcry during a year of protest over killings of unarmed black people. Justice Department on April 28th added hate crime charges to the McMichaels. They all pled not guilty to the federal counts in front of a U.S. magistrate judge on Tuesday. This is the 2 guys, the 3 guys. This is what they look like. We got Gregory, we got Travis over here, the son, and then we got Roddy Bryan over here. In state court this week, Walmsley scheduled hearings Wednesday and Thursday on several legal motions awaiting settlement ahead of the planned murder trials. Prosecutions have asked the judge to allow jurors to see text messages and social media posts they contend show a lack of racial goodwill by all 3 defendants. So speaking of the N-word, maybe those guys were using it. They include a text message exchange from 2019 when McMichael twice uses a racial slur for black people right now. So the question then is, well, that kind of shows motive, right? They wanted to go and execute an African-American kid. So that's a different question. Now, the judge might say, all right, well, we're not going to let any of Arbery's past stuff come into play, and we're not going to let any of the McMichaels stuff come into play, and we're just going to start it from scratch. Both of these individuals come to the scene, come to the incident as Blake Slate individuals, or the judge. Well, we'll see, right? We'll see if the judge splits it one way or the other. We're going to know which way this judge is leaning. If the judge comes back out and says, all right, we're going to let in everything about Ahmaud Arbery, and we're going to keep out the text messages from these from these guys. Well, we know where that judge is leaning, and vice versa. If everything from Ahmaud Arbery's past stays out and everything from these text messages come in, I think we know where that trial is leaning. Georgia Bureau of Investigation Agent Richard Dial has testified that Bryan told investigators Travis McMichael uttered a racial slur while standing over Arbery as he bled in the street. So Roddy Bryan. So this guy is saying that Travis Michael uttered a racist slur while standing over Arbery as he shot him. Wow, that's not good. Jason, and that's right. That's probably going to come out at trial. Okay, that's probably going to come out at trial. If Roddy was there on the scene standing over him and has already testified about that to Georgia Bureau of Investigation investigators, that he used the N-word while he was standing over Arbery after he shot him 3 times, that is not going to look good for a jury. Jason Sheffield, an attorney for Travis McMichael, said his client denies making that remark. All right, so, wow, yeah, that's going to be spicy. We've got, in his final days, Ahmaud Arbery's life was at a crossroads. This was posted last year, May 25th. Just a quick recap on this. Let's see what was going on with him. He decided to take a break from college, wait until the fall. He would cross 4 lanes of the Jekyll Island Causeway. 3 months ago, at the age of 25, he ran through Satilla Shores for the first time. Arbery was shot to death by a father and son who told police they grabbed guns and pursued him in a pickup truck because they believed he was responsible for break-ins in their neighborhood. Black man killed by 2 white men. Before Arbery's name joined the litany of hashtags you hear, he was a skinny kid, wanted to play in the NFL. Those who knew of him speak, nice of him, easy smile, infectious laughter, all that stuff. They also acknowledged legal troubles cropped up after high school. Carried a gun to high school, Walmart store, all this stuff. Worked at his father's car wash, landscaping business. Lee Merritt, an attorney for the family, said the circumstances of his life touch on something deeper about American society. Our ravenous criminal justice system tends to take young black men in their teenage years, introduces them to the system, and never lets them out. But when Ahmaud died, he was at a point of transition. Ultimately, Cooper Jones said nothing her son did in his short life justifies the way he died. I will get answers. That was my promise. That's the last thing I told him on the day of his funeral, that mama will get to the bottom of it. So, she's right. Nothing justifies that, right? And we've talked about this on the show. Sometimes people will say, well, can I use lethal force to protect myself, to protect my life? Well, yeah, you can. That's not what happened here, right? What happened here is allegedly these 2 guys saw somebody who was breaking into other homes. So they weren't using use of force to protect another person's life. They were chasing somebody who they thought was stealing property or maybe theoretically a threat to other people. And they were chasing him down the road. He was running away from them. They pursued him. They could have called the police. They didn't do that. And so they are responsible for the repercussions of their actions. There are consequences. If you go into the store and break the item, you got to pay for the item. They thought it was within their purview to act as unofficial law enforcement people in their neighborhood. Not allowed to do that. Somebody died as a result of it, so they're going to have to pay the consequences. Now, evidence of prior convictions. Is this stuff admissible? Right, we've talked a lot about this in the Chauvin case. This comes over from, where is this coming from? Hot Air and Nolo. So here is something that Miss Faith clipped for us. It says here by Lay Cigars. When any witness, including a defendant, testifies, his or her credibility is at issue. The fact finder, either the judge or the jury, must decide whether and how much to believe the witness. It's called credibility, yeah. That's why courts allow into evidence certain kinds of past convictions to aid in the determination of how trustworthy the witnesses. General prosecutors can't use evidence of prior convictions to prove a defendant's guilt or tendency to commit crimes. They can use them to question the truthfulness or the credibility of the defendant's testimony. Yeah, so yeah, we talked a lot about this. There are rules in the federal rules of evidence that will, you can't use evidence that's sort of showing a proclivity to do something. And if you do that, it can be more prejudicial than it is probative. It can mean that this doesn't actually help us answer the question, right? So in Derek Chauvin's case, we all know this. We spent a lot of time talking about this. The question there was, what killed George Floyd, right? What was it? And so the judge said, well, none of his prior convictions killed him. They had nothing to do with that. The cause of death, nothing to do with what caused his heart to stop beating. It was either asphyxia, or if you're a defense, looking at it from a defense perspective, it was a combination of other things, heart disease, and the list goes on. So in that situation, if we know that the only relevant inquiry is about the cause of death, any prior convictions have nothing to do with it. Now, the judge did let in the incident from 2019. Why? Because Floyd was hospitalized. He was in the hospital with a blood pressure of like 210 over something, very, very high. And because that might have had long-lasting consequences, because that may have ultimately impacted his heart, that could have contributed to his death in 2020, that bit of information comes in. But all of the other priors, none of that stuff is relevant. Same thing here, okay? If we're talking about a scene in which Ahmaud Arbery is running down the street and the McMicheals get in their car and they chase after him, what do the priors have to do with anything if the McMicheals didn't know about it? Nothing. I want to show you just a quick clip that Ma Fox put together some time ago, and he sent this over to us. He said, I really like to cover these things I pointed out before, showing Travis pointing his shotgun at Arbery prior to even being 20 feet away. All right. And so here, this is very interesting. So the big claim from people who are sort of pro Arbery, pro McMicheals, right? There's a big contingent of individuals, and I empathize with the argument that say, listen, you need to do some local policing, all right? You need to be community watch. We need to make sure that we're keeping our neighborhood safe. We're defunding the police across the country. There's protests and riots. There's stopping traffic in streets. And so we as citizens, and I'm a Second Amendment person, somebody who believes that we have a fundamental right to protect ourselves and our families and our lives. We want to maintain all of that. Now, if we're in a situation where we can't do that, that's a problem. And so some people are saying, no, what the McMicheals were doing was totally acceptable, was totally legitimate. They're allowed to police themselves or police their neighborhood, and they were responding to somebody who was coming at them, right? So in this image, now you're saying, all right, so now Arbery's running back their direction. And so if you watch the full video, that he's sort of doing a loop, it's kind of a dead end. So he's turning around and walking, running back this direction to sort of escape these guys. They've already chased him this way, and I think he came back around this way. And so now you see that Arbery is running back towards them, right? And you're going to notice that Travis is already raising the shotgun up. Okay, so basically what the defense is that this was self-defense. As Arbery was approaching him, he had to raise his gun and then fire it in order to defend himself because he was about to be assaulted by Arbery. Well, Arbery was really trying to sort of escape that cul-de-sac because they had already chased him around a number of different areas. Anyways, what ends up happening is Arbery goes around this direction, around the other side of the car, and McMicheals kind of goes around this side of the car. They come over here, and there's a shooting, and Arbery is shot and killed, and those two guys are now charged with murder. So trial is coming up in October. We're going to see where this continues to go. We've got Gregory Nicholas says, where do we draw the line on drawing the line? Yeah, that's a good question. I don't know. I think we just have to keep drawing lines. I don't know what the alternative is. Good to see you, Gregory. We got NY Renal MD in the house says, how does the prosecution get messages from the defendant? What if the defendants testified and said, we Googled him and knew he had a prior conviction for stealing? Could that direct testimony be prevented? So very good procedural questions there, NY Renal MD. I'm going to guess that when they were arrested, they probably got warrants to search everything, right? Their house and all of their property. They were involved in a murder. They're doing an investigation to figure out what happened there, right? So phones are going to be naturally a part of that inquiry. And what if the defendants testified and said, we Googled him, knew he had a prior conviction for stealing? So that would be different, right? Because that would explain some direct evidence that they utilized in order to make the decision that they did. Now, that would require them to testify, right? They would have to take the stand and testify, which almost never happens. And I think we know that they didn't know anything about him because we saw the images of it, of a lot of the surveillance footage from around the neighborhood. And I just don't think that they had any indication of who this person was. And nobody knew who he was. And there was some indication that there was some, black kid who was stealing things or was looking suspicious. But again, that does not justify the killing of another person, right? We're talking about property. We're not, which is very inconsequential relative to human life. Call the police for that type of stuff. Don't get in your car and go chase down a kid because they stole a 2x4 out of a house that's under construction. All right, great questions. And I want to thank all of you who sent those in today. They came over from watchingthewatchers.locals.com. And I want to welcome some new supporters over there. We've got Dog Whistle in the house. We've got Lynn's Crew. Welcome. We have NWH_Scott is in the house. We have I Am Tech. I want to welcome all of you. Thank you, Dog Whistle and Lynn's Crew. Also, thanks to the great questions that came over today from all of you. You see yourself here on the screen. Thank you so much. We've got a lot of good stuff over there. If you're not already on Locals, you should be. You can grab a copy of my book. It's for free. It's called Beginning to Winning. There's a free PDF. You can also download a copy of the slides that we went through today, a copy of the impeachment party documents. If you want to impeach any elected official, I have a template for you. Just download it and do it. We have existence systems template as well. You can get that for free. You can share links throughout the day, and you can meet great people. There's a lot of good reasons to be over at watchingthewatchers.locals.com. And I've got two more for you. Number one, we've got a monthly Locals meetup. It's going to be taking place via Zoom on Saturday, May 22nd. There's a registration form over at watchingthewatchers.locals.com. So when you go over there, you can just find the top pinned comment and you'll just click that. Right? You got to be a supporter to attend these Zoom meetings, but if you are, just click the registration link. You're going to get reminder emails. The whole thing should be automated. We look forward to seeing you on the 22nd. If you want to come to another event, this one's going to be a little bit different. This is our law enforcement interaction training. It's going to be taking place June 12th, 12 to 2 p.m. Eastern time, probably 12 to 1:30, but I'm going to keep another additional 30 minutes or so to hang and share some questions and kind of kick the can around a little bit. So come join us there as well. June 12th, Saturday. It's going to be 9 a.m. Arizona time, 12 p.m. Eastern time, which will be a lot of fun. Law enforcement interaction training. What happens if you get pulled over and a cop says, "Have you had anything to drink tonight, sir?" What do you say to that? Do you say no? What do you say? Well, you're going to have to come find out. Saturday, June 12th. And it's over at watchingthewatchers.locals.com. And that is it for me, my friends. I want to thank you for being a part of the show. Before we get out of here, quick reminder that I am a criminal defense lawyer here at the R&R Law Group. We're in Scottsdale, Arizona. We love helping good people who have been charged with crimes find safety, clarity, and hope in their cases. Love to help to do that. And we're quite good at it. We can help with any type of criminal charge in the state of Arizona. Can be things like DUIs, drugs, domestic violence, misdemeanor cases, felony cases, anything and everything in between, even old cases. If you have an old warrant you need to quash, or you have the desire to vote again, you can restore your rights, you can possess a firearm, vote, apply for federal benefits, and the list goes on and on. There's a lot we can do. We offer free case evaluations. We're right in the heart of Scottsdale. We have a nice office. We'd love to have you come by and just meet with our team, see if we can help you get through this situation, because there is a lot we can do. I mean, a lot of people come into our office with zero hope. They just don't realize how much we can do to be supportive of them in this difficult time. So if you happen to know anybody, we would be honored and humbled that you send them our direction. We'll make sure we take very good care of them. Other than that, my friends, I want to thank you once again for being a part of the show. We are going to be back here tomorrow, same place, same time. However, I may be in a different location. I may be in studio number 2 because I have an event all day tomorrow. I have a 2-day event that's taking place all day tomorrow and Friday, and so I may bunker down out of the office, and we may do the show from a separate location, but I have to do a trial run to make sure that it's all working. So doesn't change anything for you. You have to be right here, same place. You already know where to go. And one other quick note, by the way, I think we're live streaming on Odyssey, so I set that up today. Don't even know if it's working yet. I'm going to check right after the show, but I transferred some library coin over there, and I've got that set up. So I think we might be live streaming over there right now. I hope it's working. I'm going to check, and then we are probably going to be trying to get set up over on Rumble next. So super excited about that. And remember this, right? We had this conversation when Trump was throwing off all the platforms. Everybody was freaked out. You know, there's nowhere else to go. YouTube is the only place. Well, now Rumble has live streaming. Now Odyssey has live streaming, and Locals is coming out with it too soon. So a lot of the alternative platforms are really, really building themselves up, and it's because of you. It's because of your support. It's because people are sick of it, and they want to go and be with other people where there are free thoughts and free conversations taking place. So I want to thank you once again for being a part of that. It's really humbling, and I think it's very exciting that we are all sort of being a part of the solution. You know, oftentimes we kind of wonder what we can do to move the needle forward in this country, and this is one of them. Sort of this slow abandonment of these big tech platforms in favor of some of these other platforms, and I'm excited to be a part of it, and I appreciate all your support in that endeavor as well. All right, so enough out of me. Same time, same place tomorrow, right here, 4 p.m. Arizona time, 5 p.m. Mountain, 6 p.m. Central, and 7 p.m. out there on the East Coast for that one Florida man. Everybody have a tremendous night. Sleep well. I'll see you right back here tomorrow. Bye-bye.